What's going on, guys? Welcome to the circus. And today I'm going over, I guess, what is no longer Epstein updates. I guess we should call them Maxwell updates. I don't know, whatever you want to call it. Got a fresh one for you. The last episode I had done, the judge had ruled that a bunch of evidence that the lawyers had in the Guffrey civil suit was to be destroyed. And the way the news was talking about the evidence, it was as if they were saying all the files were going to be destroyed that the appeals court had previously said to release. So when the news hit the stands today that Judge Preska had ruled to release the information, I was a little bit shocked. I was a little bit confused and frankly worried because I don't ever want to bring you guys bad information or misinformation, and it's difficult to make sure that you're putting out the best product that you possibly can. And I mean, legitimately, around the beginning of the month, she did not only say that the files were to be sealed, she said they were to be destroyed. And that was really what prompted me to make the video, because at the same time Maxwell was getting arrested, Judge Preska was ordering that these documents be destroyed. And it had me thinking immediately, I have to find out what the deal is here. How can the evidence be destroyed and released at the same time? And in order to get some clarification, I had to go all the way back to January of this year. Judge rules that Epstein documents in New York court case will stay under seal for now. Skipping a little bit, at question are motions in the case that were never decided by U.S. District Court Robert Sweet. A federal appeals court ruled last year that motions upon which Sweet had passed judgment should be unsealed. But U.S. District Court Loretta Preska concluded that the undecided motions, in contrast, were not, quote, judicial documents subject to the presumption of public access and should remain under seal. Guffrey, who sued Maxwell for defamation in New York federal courthouse in 2015, had asked Preska to unseal documents that could reveal more information about Epstein's operation, including the undecided motions and related filings. The Miami Herald intervened in the case, also asking for the documents to be unsealed. Other media organizations have filed briefs in support. In an opinion released Monday, Preska said that the purpose of public access was to monitor the conduct of judges and how they arrive at their decisions. She noted that Guffrey and Maxwell had settled their claims in 2017. Since the dispute between the parties had concluded, Preska said there was no compelling reason to unseal the motions. Judge Sweet died last year. With respect to motions left undecided by Judge Sweet, Preska wrote, there was never, and now never can be, a judicial decision-making process that would trigger the public's right to access the undecided motions and the documents relevant to them. However, the judge also acknowledged the, quote, great deal of public intrigue surrounding the unsealing of the documents at issue here. She said that some of the undecided motions could be unsealed if they are demonstrated to have been relevant to Sweet's decisions. Preska has also called a Thursday press conference between attorneys Guffrey, Maxwell, and the Miami Herald to discuss an individualized review of the relevant documents that are to be released. Sandy Borer, an attorney for the Herald, said Tuesday that, quote, we believe the judge's ruling too narrowly construes the law regarding openness of judicial records and access to those records and intend to ask her to reconsider. Managing editor Rick Hirsch said the Herald wants to hear what is said before the judge Thursday before deciding on a course of action. Okay, so here's the situation as I understand it. Again, novice, not a member of the bar, nor do I ever want to be. So, in the civil suit, there were motions that the judge had reached a decision on and motions that the judge had not reached a decision on. And the parties in 2017 decided to settle the case. When they settled the case, they did it, and some of the motions had not been ruled on by Judge Sweet. So they came to an agreement, and they closed the case. So when the case is closed, what Judge Preska is saying is that The only reason they should release any of this information is for judicial transparency, just so that we can see how the judges are making their decisions. That's it. That's the only reason why we have to see these documents, the public. And she said, since some of the motions were not ruled on by Judge Sweet, and now since he's dead, they can't be ruled on by Judge Sweet, plus the case is closed, the judge ordered that all paperwork surrounding motions that were never decided on by Judge Sweet are not able to be unsealed. Furthermore, the judge says that the lawyers that are currently representing Guffrey should not even have those documents. Okay? And why do they say they have the documents? So the case is settled, the records remain under sealed, and some of the motions don't get filed on. In the meantime, Guffrey switches lawyers, and the lawyers end up with paperwork from the original lawsuit that they shouldn't have. And this is how they explain that they have it. Manhattan federal judge Loretta Preska said she was, quote, troubled to learn during oral arguments last week that Guffrey's lawyers from the firm Cooper and Kirk had been given sealed records from her since settled suit against Maxwell, who Guffrey claims recruited her to have sex with Epstein and his pals while she was underage. The other men allegedly include Dershowitz, whom Guffrey is suing for defamation over his public denials of her accusations, including calling her a certified complete total liar, and who is countersuing Guffrey for causing serious harm to his reputation, his business, and his health. As a practical matter, the court would be surprised, shocked even, if Cooper and Kirk was not in some sense using the Maxwell discovery in its representation of Miss Guffrey in her action against Mr. Dershowitz, the judge wrote. Preska also rejected claims by Guffrey's lawyers that they were entitled to the evidence obtained from her former attorneys at Boies, Schiller, Flexner because they'd been hired to represent her in the Maxwell case. The 13-page ruling said Cooper and Kirk has not, from what the court can tell, been actively working on the case. Preska directed the Cooper and Kirk lawyers to destroy the evidence along with, quote, any material including work product derived from it, and to submit an affidavit afterwards. This is what we talked about. She also denied the request that Dershowitz made to have access to all these documents. Although both cases are related, she said, they are not coextensive because Guffrey's suit against the famed Harvard law professor involves a much narrower range of conduct than was at issue in her action against Maxwell. The court is thus skeptical that judicial economy would be served by handing Mr. Dershowitz a mountain of discovery from a separate case that may not even be relevant to his defense or to his counterclaims against Miss Guffrey. In a footnote, the judge also said that although she didn't think Dershowitz would be brazen enough to release the evidence, she was concerned that he might be tempted to be more cavalier with the sealed materials to help defend his reputation. We jump over here to the Daily Mail. The Guffrey v. Maxwell protective order has long kept the potentially explosive Epstein files under wraps. Preska reasoned that the protective order only provides access to the preparation and trial of Guffrey's settled lawsuit against Maxwell, and since that lawsuit is inactive, Cooper and Kirk necessarily cannot play an active role in litigating them. When asked to explain how those materials came into the firm's possession, attorneys from Cooper and Kirk explained that they had obtained access to the materials because Miss Guffrey retained them both to represent her in Guffrey v. Dershowitz and to represent her in conjunction with the Boies Schiller firm in the Maxwell case. So it sounds like the Boies Schiller firm was trying to gain access to these documents, and the way that they were going to do it was by claiming a continuity of representation of Virginia Guffrey, while all the background documents and all the stuff surrounding the sealed closed lawsuit would not be accessible to your average person or anybody for that matter. The law firm who litigated it would have all the documents surrounding it. And so that's how they tried to get these documents into the possession of her new lawyers. And that brings us to today. Epstein floodgates open as judge rules explosive docs detailing Ghislaine Maxwell's sex life can be unsealed in Virginia Guffrey's defamation case within a week. A judge today has ordered the unsealing of a vast trench of documents related to Jeffrey Epstein which could shed light on his friendship with powerful men accused of having sex with his victims. Judge Loretta Preska said that 80 documents, which will run to hundreds of pages, should be made public within a week. The documents will include depositions from Ghislaine Maxwell, which could explain her alleged role in Epstein's sex trafficking operation. They could include details about Maxwell's sex life that her lawyers have previously tried to stop from being released, relating to a 7-hour, 418-page deposition Maxwell gave, which her legal team said was extremely personal and confidential. In filings, Maxwell's lawyers have called the depositions a series of efforts to compel Maxwell to answer intrusive questions about her sex life. The documents will also include communications between Maxwell and Epstein from January, when Virginia Roberts made explosive allegations about them in court papers. Although the case is separate from Maxwell's criminal case, one of the unsealed deposition documents is linked to her perjury charge. The case was settled in 2017 for an undisclosed sum, but media organizations sued for documents in the case to be made public. By the way, there's our judge. During the hearing at Manhattan's federal court, Judge Preska said Maxwell's right to privacy was outweighed by the need for the documents to become public. She went through the dozens of documents, which include Guthrie's depositions and various sounding legal papers. The contents, however, could be explosive and may contain fresh evidence against the wealthy elite who socialized with Epstein. After the ruling, Maxwell's lawyer, Laura Menninger, asked for a 2-week delay in the unsealing so they could file an appeal in the Second Circuit in New York. Menninger said, "There have been some significant changes with respect to my client's positions and perhaps known to everyone listening to this. While we were speaking about a potential ongoing criminal investigation before, since that time, Ms. Maxwell has been indicted and a trial has been scheduled. Now we are in a vastly different position and have grave concerns about our client's ability to receive a fair trial given the intense media scrutiny around anything that is unsealed." Guthrie's lawyer said she wanted the documents made public as swiftly as possible. Judge Preska said if the second court had not ruled within a week, then the files should be made public. So, inside of this news story, we're supposed to feel good, right? This is a feel-good story. These documents are going to finally be released. But here's the rub. This is why the two stories didn't match up. Because I would say that a large amount of the documents that people were trying to get unsealed were the very ones that she had destroyed. And the only thing that she's unsealing are the documents related directly to motions that Judge Sweet had ruled on. All the other investigation paperwork that the lawyers had that they were trying to get released is off the table now. The address book with thousands of names in it, off the table now. And we'll never know what evidence was pulled away. Because, like I said, she didn't order those records to be resealed or to remain under seal. She ordered Guthrie's old attorneys to destroy that evidence that wasn't directly pertaining to motions that Judge Swift had ruled on, to destroy that evidence and then to show her how they destroyed it when they were done. So you can imagine there is at least a possibility, let's say that a significant amount of the data, both in information and names of people that we were looking for, fall into the category of stuff she had destroyed. And the reason why this is all confusing is because they're not putting all the information in one article. If they'd make one article that would cover this story from the day that the Court of Appeals ruled that the documents should be unsealed until today, in one article, people would see that the judge ruled that a lot of this supposed documentation that's going to give us names and tell us what's going on was removed from the evidence list before it was unsealed. It was destroyed. We don't even know what was in it. The only thing that we do know is that Guthrie's old attorneys tried to play a switcheroo with her new attorneys and tried to say, oh, we're still working this new case, so that's why this new law firm has our paperwork from the old case. That paperwork was that important to those lawyers. They wanted that paperwork unsealed. If they didn't, then the only thing that would have ever been released would have been the documents directly pertaining to Judge Sweet's rulings. So although you will look on the internet today and you will see news about Documents being released, and yay, I'm glad something's coming out. We'll get to see some transparency. The fact is, the evidence in large amounts that we were actually looking for was in possession of her lawyers, her previous lawyers. And that evidence was destroyed. Now, the evidence that was left, which would be the depositions from each person and paperwork surrounding motions that the judge did rule on, all of that paperwork is able to be unsealed. All of it's not being unsealed, only some of it. But even worse than that, they're not telling people that Judge Preska ordered a bunch of documents destroyed a half a month ago. See, first the appeals court rules that everything should be unsealed. Then Preska says she needs to go one by one by one. And then she finds out supposedly that Guffrey's lawyers have way more documents than they're supposed to have access to. And she says whatever you've got that you're not supposed to have access to must be destroyed, is not admissible, cannot be unsealed. Boom goes the dynamite. We lost a lot of paperwork, and you know we did because Dershowitz, when he filed to see that paperwork, he included and third parties. The documents that Dershowitz wanted, he's not getting. The judge is going to unseal a bunch of stuff, but it's not what Dersh wanted. Dershowitz wanted that paperwork that her lawyers down in Florida have. The paperwork that her lawyers down in Florida gave her lawyers up in New York. The paperwork that Preska just ordered destroyed. So they staggered the information. 2 weeks ago, they say Preska has ordered all of this documentation to be destroyed and it's never going to see the light of day. They wait a little while, and then back in the news cycle, here comes the judge, same judge. Oh, it's got a picture of her, and oh, we're all so happy. Here come these documents. They're going to be unsealed. And they don't even tell anybody about the article 2 weeks ago. I mean, not one article I read through today mentioned the articles from 2 weeks ago. That's what made it so bizarre to me. I was like, okay, so we went from evidence is being destroyed to they're releasing all the evidence. And I just wanted one article that would explain all of it. Well, these are the documents that were ordered destroyed, and these are the documents that are being released. And I couldn't find it, at least as of not yet. The judicial events have been separated. So while all of the parties involved know very well that the really damning documents were in possession of her lawyers in Florida and were destroyed, they're going to make a big hoopla about releasing her testimony. If it was not ruled on directly by Judge Sweet, and he's gone now, then it cannot be unsealed. Not only can it not be unsealed, but it must be destroyed so that nobody ever knows what was in those documents. So here we are in Mirror World towards the end of July, and we have a celebratory moment because some documents are getting released. But the truth is that 2 weeks ago they told us that the documents we wanted to see, they destroyed. And boy, oh boy, I wonder who was in those documents, because whoever they are, they've got some pull. Because this little smoke and mirrors thing that they pulled right here, this little hoodwink, it's pretty fantastical, and it involves the media. The Miami Herald is not even reporting it all in one article. So while I'm happy that there is a ruling that we're going to see some documents, and I am thinking that there are going to be some names in that information, the only thing that we're going to gain is insight into what Guffrey was thinking and what Maxwell was thinking. And remember, these are just what they're saying. This isn't evidence. So if somebody's name is dropped in their testimony, it's not evidence. So this judge's ruling that they're propping up today, and they're trying to make it look good for everybody, because a few weeks ago they had the opportunity to exclude evidence. If somebody was going to be involved in a conspiracy to exclude that evidence, they got the opportunity a few weeks ago. So I don't know if you guys agree with the reasoning or not. I'm not good at legalese, not a lawyer, but I do know that when the media reports that a judge is ruling that significant and important documents in a case must be destroyed, not sealed, but destroyed, and then 2 weeks later she rules that the paperwork that's left can be unsealed, but none of the articles talking about her ruling today mention that she had evidence destroyed. And these are the same exact outlets that wrote articles about her ordering the documents destroyed. They just won't put that information in the article today. If they really just destroyed all that evidence and then submitted a brief to Preska, and then Preska said, okay, well, now we're going to release all the Guffrey files, all of them. Well, she can say that because the ones that she didn't want unsealed, she ordered them destroyed 2 weeks ago. So now we can say all the evidence that exists in the Guffrey trial, we're going to get it unsealed. She wasn't destroying all of it. And of course, everybody will be like, oh, the paperwork that she ordered destroyed it didn't matter. There's no hidden hand. She's not trying to protect anybody. I'll leave you guys to think whatever you would like to think. All I know is that 2 weeks ago, she said, you don't have access to anything that the judge didn't rule on. God knows how many motions those lawyers had made to submit evidence when Guffrey and Maxwell finally agreed to settle the lawsuit and it was ended. There could have been 100 motions to enter evidence. And now she's saying all those motions that the judge didn't rule on, they are gone. And listen, they're gone. It's destroyed. And yet, the headline today is, Judge orders all evidence in Guffrey trial released. Well, isn't that something? So that's the story on the Guffrey files. They are going to unseal her deposition, Maxwell's deposition. They're going to unseal a lot of things as long as they're directly connected to rulings that the judge made. All of the evidence that was under motion to be submitted has already been destroyed. And so it is not inaccurate to say that they are looking at everything to potentially unseal it. And it also makes things make a little bit more sense why they didn't just have it put back under seal. Because if they had just put it back under seal, then they wouldn't have had the headline today. And it'll happen in a week if the appeals court doesn't decide on it. But it's only going to be that which was not destroyed by the judge's order 2 weeks ago. And let me tell you, Maxwell's lawyers, they were arguing against the releasing of these documents before she was arrested. I read that document to you when I covered this the first time. They were saying that she was going to potentially be indicted and that this could potentially poison the jury pool. Now, she has been indicted and they're saying it will poison the jury pool. If we're being honest, most people have already made their minds up about this case. So, although they are going to file for an appeal, I feel like they're screaming at the wind, but you never know in America's judicial system. She might get this on appeal, and they will even seal up her deposition and Guffrey's deposition, which is essentially all that's getting released now. All the evidence that had been submitted, yet was not, the motions were not ruled on, that stuff is gone, destroyed. What do you guys think? Do you guys think that this is just a regular old legal proceedings? Or do you see the okey doke that I see in here where, now the judge gets to say she's considering all the documents in the Guffrey case because 2 weeks ago she ordered the documents that she didn't want to consider be destroyed? Or is it, this is legally what she had to do? Guffrey's current attorneys had no rights to the paperwork that her previous attorneys had, even though the cases are related. So while I hate to be the bearer of bad news, in my humble opinion, there isn't going to be nearly the smoking gun that we thought we were going to get from the release of these documents that we thought would be there. And personally, as a side note, I'm just curious to see Guffrey's lawyers, they mentioned that little black address book specifically. And he said it had potentially thousands of names in it. I would like to know if that little black book is part of the documents that are being considered for release, or if that black book was in the stock that she said must be destroyed. And at this point, we just don't know. So, sorry I didn't give a full picture on this situation a couple of weeks ago when I covered it. I hope I cleared it up a little bit. Like, share, sub. The documents will be down in the comments section as always. Love you guys. Stay safe out there. Stay positive. I'll talk to you next time.